Good evening. This is Rahul Magan here is a Group Chief Executive Officer, Treasury Consulting. But today, my deliberation won't be as a hedge fund manager. Rather, my deliberation would be as a law person. You know that I am having ample of experience in EOW. EOW is nothing but Economic Offences Wing. Just like we are having Central Bureau of Investigation, we are having Enforcement Directorate, we are having special units of state police like EOW unit of Delhi Police, Bombay Police, and so on and so forth. And in the last 10 to 15 years, at least in the last 10 years, I did notice that the frauds, the scandals, the cross-border manipulations, especially in the economic offences wing section, grew exponentially. And unfortunately speaking, with the invent of crypto, although the crypto was invented for a positive purpose, the crypto was invented for a purpose whereby you can have a decentralized currency. You can have a virtual asset, but unfortunately, without quoting any specific exchange or any specific crypto personality, we did notice that in the last many years, crypto end up being an instrument to do the money laundering. In the last 6 to 7 months, specifically speaking, many venture capitalists and private equity firms lost heavily in crypto. And why did they lost heavily? Because they invested heavily in the venture capitalist, in this crypto exchanges, crypto venture capitalist firm, and they lost heavily. Even in the countries like Singapore, who on paper claim to be a law-abiding country, this country himself faced many meltdowns in crypto. So, to conclude this story, economic offences wing is spreading. There is no doubt about that. And we also need to appreciate one thing, that the law which is made to curtail the economic offences wing, this law needs to be amended on time to time basis. So example, if I give you a simple example, crypto, the virtual assets. If I give you a simple example, NFT, non-fungible tokens. If I speak about how a crypto exchange work, if I speak about how the buy-sell algorithms are happening in crypto, if I speak about the UBO, which is called Ultimate Beneficial Owner of any crypto exchange, then these all are the things which are very much in the public. When I say, please let me first summarize this. When I say it is very much in the public, I mean to say there is a good quantity of discussion which is happening in the public. And many a times I participate in these discussions on LinkedIn and whenever people are chatting with me, the friend circle and all. But unfortunately, when we speak about the legislation, and when I use a word legislation, I mean to say the legislation of the globe. Because technically speaking, money laundering is a concept which is falling under the jurisdiction of many setups. Few setups are societies, few setups are body corporates, few setups are association of people, shortly known as AOPs. Few setup are companies and few setup are advisory bodies. So example, if we speak about Bank for International Settlement, like Bank for International Settlement is an advising body. It is not a punitive body. Like they will give you an advice, but if you follow this, that's up to you. If you do not follow this, that is again up to you. But having said that, the Bank of International Settlement do not have a punitive power. But when it comes to FATF stands for Financial Action Task Force, then In my parlance, they more or less have punitive power in place. That's a separate thing that somebody wanted to exercise this punitive power, and sometimes people do not wanted to exercise this punitive power, and that is debatable. Nowadays, now, first of all, when it comes to the money laundering law, then we have one of the prominent laws which is called Prevention of Money Laundering, which is called PMLA 2002. Government of India, which is central government, keep updating PMLA on time to time basis, and henceforth this ends up become a very dynamic law. And I always appreciate this effort of the central government because this law is really very dynamic. This is no more a static law. More importantly, there are case laws which are coming up in public, and here we should be thank you to the honorable institutions like high courts and not to mention the Supreme Court of India, because these honorable institutions judgments, especially the ED judgments, the difference of opinion, just like Section 45, twin bail condition, the special court, Section 43, 44, that you have the role of the CRPC in PMLA, which is Section 65. This is really highly, highly debatable. On time to time basis, the legal fraternity, a lot of voices are coming up in the public, and we are very fortunate the courts are listening and sharing their opinion. PMLA is divided into many parts. So first thing which we need to understand that PMLA is something which is not a single act. That is something which you need to understand. So it is not the 73 or 75 or probably 80 sections which you need to sum up and your job in the PMLA is over. I completely disregard that because like I said, and honestly speaking, I finding PMLA more interesting than Indian Penal Code because this is very, very dynamic. More importantly, PMLA is having the allied acts also. Allied act means, now what is the simplistic definition of allied acts? We need to learn. Sometimes what happen, a country have many regulators. Like if I speak about US have Securities and Exchange Commission. If they have CFTC, Commodities Future Trading. They have FTC. And they have many regulators in place, FBI and so on and so forth. Now, sometimes what happen, many regulators perceive a single thing from a different perspective. Example, when I speak about Reserve Bank of India. In India, when it comes to EOW, which is called Economic Offences Wing, then there are two bodies which comes into the mind. Predominantly the ED. ED stands for Enforcement Directorate. Some people mention this as Directorate of Enforcement. And another is your RBI, which is Reserve Bank of India. Though SEBI, Securities and Exchange Board of India, is playing a vital role in that to me. But having said that, like I said, the guidelines which SEBI is making or SEBI has made, example, recently they made a changes in LODR. LODR means Listing Obligation and Disclosure Requirement. And specifically speaking, the Regulation 30, which they made, which is nothing but the materiality, because the previous LODR is not covering materiality in quantitative terms. So it is subjective. If I wish, I will disclose this as per para A, para B of Schedule 3. If I wish, I will not disclose this. This is completely subjective in nature. But having said that, now SEBI, Securities and Exchange Board of India, they are coming out from the subjectivity to objectivity. And what they did, they summarized, they added the quantitative disclosures in that. But technically speaking, when I speak about the quantitative disclosures, then I am having a huge interpretation issue. And that interpretation issue is the materiality policy. I repeat, the materiality policy is to be created by the board. Now, when I say board, I'm talking about the board of the company. So I once again take my favorite company as an example, Ram Lal Chole Bhature. Ram Lal Chole Bhature is a listed company in India, assuming, and this company is providing FMCG services. They are providing chole bhature, sweets, and all this, that. Now, Ramlal Chole Bhature, since it's a listed company, and assuming the share price of Ramlal Chole Bhature is 100 rupees, assuming, in that sense, the materiality policy of Ramlal Chole Bhature to be decided by the board. Excellent. More importantly, one of the board or the designated member approved by the board to decide whether a relevant event falls under materiality or not. And very important thing, the overall materiality policy to be supervised and managed by the board. So where is the audit committee? Where is the disclosure committee? Where are the independent directors? If the materiality policy to be decided by the board, if the materiality policy to be managed by the board, if one of the representative of that materiality policy is a board member or a designated member approved by the board, then what is the use of audit committee? What is the use of disclosure committee? And more importantly, what is the use of independent directors on the board of listed companies? Because the prime intention, I repeat, the prime intention when it comes to the independent directors on the board of listed company is to make sure that the shareholders can have a peaceful sleep, because they are sleeping and independent directors are waking. Because independent directors is termed as a voice of shareholders. Because you know that if you are a board member, you are getting a salary from the institution, you are working in that institution, then some bias would come. There is hardly any doubt about that. But the prime reason behind the designing of independent directors is this. But having said that, this, to me, at least in the countries like India, is really very difficult to digest. We have infrastructure leasing and financial services. We have Diwan Housing. We have PMC Bank. We have Yes Bank. And very recently, India is facing Byju's, Farm Easy. There are so many directors we have on the board of these companies. But did you ever been to a single director who came in public and said that something is happening? Yes Bank collapsed somewhere in March 2020, which is precisely 3 years, 3 months from today, around. But even before few weeks of the collapse, no independent director, no credit rating agency, no auditor, no one came in public and said that this is something which is going to collapse. Henceforth, we really need to understand that the PMLA rules. Now, first of all, let me tell you that this is a very important rule. I cannot cover each and everything in one video. Let it be very honest. I need minimum 20-25 videos to cover only the PMLA rules. And considering my busy schedule, it will definitely take some time. The Prevention of Money Laundering, Maintenance of Records Rule 2005. I first of all congratulate the Directorate of Enforcement for having this rule. But one thing which I really fail to understand, that this rule is nothing but the replica of Chapter 4. Actually, like I told you earlier also in my law videos, the Indian stat is divided in terms of chapters, like CRPC also, criminal procedures, CPC also, civil procedures, Indian Evidence Act, and everything is divided into chapters. So the chapter 4 is talking about the maintenance of records, and that's very important. Let me tell you, it talks about maintenance of records by financial institutions, the banking setup, and more importantly, the intermediaries. Most of the people barely understand the difference between custodian and intermediary. They feel that both are same, but technically they are not same. Okay. Henceforth, the prevention of money laundering, maintenance of records, Rule 2015, and specifically speaking, Rule number 5, since Rule number 6 has already been omitted. Rule number 5, Rule number 7, Rule number 8, and Rule number 9. Predominantly to me, Rule number 8 and Rule number 9, they definitely need an overhaul. Why they need an overhaul? Because now there are many different banking setups working in India. India having private banking, India holding investment banking, India holding private equity firms, India holding the venture capitalist firm, India holding the angel debt, India holding variety of financial institutions. All these variety of financial institutions needs to maintain the data of the transactions which they are doing. That's very important. So let me first study the section 11. Now, section 11 predominantly say, section 12, I'm reading about section 12, which speaks reporting entity to maintain records. Every reporting entity shall maintain a record of all transactions, including information relating to transactions covered under Clause B, in such a manner as to enable it to reconstruct individual transactions. Furnish to the director within such time as may be prescribed information relating to such transactions, whether attempted or executed. Remember, attempted or executed. The nature, the value as may be prescribed. In our financial market, there is a term called dealt and there is a term called quoted. Now, dealt means the deal is done, while the quoted means the deal is not done, but the rate was taken and the party felt that they are not happy with the rate, so they wind it up. Henceforth, the words attempted or executed, it's something beyond interpretation, something which has to be interpreted in a very rightful manner. And it would be better if that interpretation is aligned with the case law. Because that attempt or executed. So let me give an example, right? So any private equity firm having a setup in US, that private equity firm also have a setup in India. There are many private equity firms who have set up in US, they have set up in India, Europe, Australia, Singapore, and majority of the places. Now, the US principal wanted to invest $30 million in Indian setup. $30 million, just a hypothetical example. And that $30 million to be infused in a fund. And that fund to be used for a buyout, probably startups, maybe mid-sized companies, or maybe matured companies. Assuming before investing this $30 million, the Indian setup did the due diligence. And after doing the due diligence, they got to know that the kind of profitability or the kind of quality they are expecting, they are not getting. So they shrug off. They're saying, okay, we are not going with this. Just close out this deal. Now, this is called attempted and executed. Henceforth, this PMLA, which is rule PMLA section 12, specifically talking, which comes under chapter 4, that attempted or executed word, which the PMLA is talking, I will further show you that this is PMLA, Prevention of Money Laundering. And that's a bare act, guys. That's a bare act. The full commentary is here. You can see that. This is commentary. Actually, in laws, you have two things. Number one, you have bare acts. And number two, you have commentaries. I always believe that you should have bare act and commentaries both. You should first learn from bare act. See in short and crisp the intent of the legislation, why they wanted to have this act, And once you're able to understand, or once you're done with your understanding that why the legislation wanted to have this, then you should look at the commentary, because commentaries have case laws. I'm not saying that all commentaries have all case laws. It's up to the author. Few authors have updated case laws, few authors may or might not have updated case laws, but I generally prefer commentaries. And then you should look at the website of Honorable High Courts and Honorable Supreme Court, because on time to time basis, they keep uploading EOW's judgment on their website. Absolutely free, nothing to pay. And now, Supreme Court having ECR also, ESCR. You just go there, click whatever short name of the judgment, case law you put, and you will get that. That's really very, very fantastic. Let it be honest. So in this case, section 12, chapter 4, which they are talking, that is really subject to interpretation issue, which means attempted or executed. Being a financial person, I'm having huge interpretation issue, and I don't think that interpretation issue can be resolved until Honorable Supreme Court came up with a case law. Because from an angle of the financial market, and specifically from an angle of the foreign exchange, the attempted and executed is something beyond interpretation. Let me tell you. Third, which makes the matter worse and more confusing, is maintained records of all documents evidencing identity of his clients and beneficial owners, shortly known as BO, as well as the account files and the business correspondence relating to clients. Now, let it be very honest, guys, that definition of business correspondence is something which is subject to huge interpretation issue, because from an angle of the financial market, the business correspondence is having lots and lots of interpretation issue. And then it's saying, I'm skipping this subclause 2 and subclause 3. I'm directly coming to subclause 4. The records referred to the clause E, which is, I just told you, of subsection 1 shall be maintained for a period of 5 years after the business relationship between the client and the reporting entity has ended, or the account has been closed, or whichever is later. And if I link this with Rule 6, though omitted, then this 5-year used to be 10 years. Henceforth, when I study the PMLA Act of India, I have already started my study on the PMLA Act of the Singapore and also the PMLA Act of the London, which is the United Kingdom. I see a huge interpretation issue in the PMLA Act of India. And I requesting the central government read with the Directorate of Enforcement, ED. The time has come when we need to have a serious look at the PMLA, because the selection of the words is something which is little confusing and subject to interpretation issue. This is Rahul Magan from Treasury Consulting Group. You know my personal number, +91 9899 242 978. 9899 242 978. Thank you. More interesting videos on the cards. But guys, before I leave, let me tell you one thing upfrontly, that without having any financial background, if you study the PMLA, then it have more interpretation issues when you study with having financial background. And when I'm using a word financial background, I mean to say a practical experience in the financial markets. Because once you have the practical experience as a backdrop and you're trying to link this, it really makes a difference. Good evening, ladies and gentlemen. This is Rahul.